Have you ever been watching a courtroom drama right at the climax and the lawyer yells, "Objection," and suddenly the most crucial piece of evidence is thrown out? It can be so frustrating. Well, today we're going to pull back the curtain on that. We're diving into the invisible rulebook that dictates what a jury is actually allowed to hear and why some of the juiciest information never makes it past the judge.
So the big question is, why? I mean, if the goal is to get to the truth, shouldn't we want all the information we can get? It seems a little backward, right? But the thing is, an unfiltered flood of information can actually do more harm than good. It can confuse, mislead, and derail the entire process of getting a fair trial.
The best way to think about it is that the judge acts as a gatekeeper. Their main job is to filter everything, to make sure the trail stays on track. They have to shield the jury from stuff that might be totally misleading or just plain unfair, making sure that the final verdict is based on solid facts, not just gut reactions or irrelevant drama. Okay, so how does this gatekeeper decide what gets in and what gets tossed out? It's not just a random gut feeling. There's a fundamental principle, a sort of golden rule, that every single piece of evidence has to pass before a jury ever lays eyes on it. It's a two-part test. And here it is. It's actually pretty straightforward. First, is the evidence relevant? Like, does it actually have anything to do with the case at hand? And second, even if it is relevant, does it break any other specific rules? You know, things like hearsay or evidence that was gathered illegally. Now, both parts are super important, but we're going to focus on that first massive hurdle, relevance. Because honestly, if evidence isn't relevant, nothing else even matters.
So let's get into it. What does relevance actually mean in a court of law? It's not just about being kind of sort of connected or, just interesting. The legal definition is way stricter, and it's the absolute bedrock of the whole system.
I know that sounds incredibly complicated, logically probative or disprobative. But all it really boils down to is a simple question. Does this piece of information make a key fact in the case more likely to be true or less likely to be true? If it moves the needle even a tiny bit in one direction or the other, it has a shot at being relevant. And this quote really gets to the heart of it. It's not some abstract academic puzzle. Judges are expected to use their common sense and life experience. They're basically asking, in the real world, does this piece of info logically connect to what we're talking about? Does it just make sense?
This example shows perfectly why context is everything. Look at the left side. A guy speeding 40 minutes before a crash is relevant because alcohol was involved. It points to a pattern of reckless behavior. But now look at the right. The exact same act of speeding, but with no alcohol, a judge might throw that out. Why? Because it could be a total coincidence, completely unrelated to what happened 40 minutes later. All right, so let's say a piece of evidence passes that first big test. It's relevant, great, but it's not automatically in. It still has to fit neatly into one of three specific categories to be considered admissible. So these are the three buckets. Every piece of admissible evidence has to fall into one of them. You've got facts in issue, which are the main questions of the case. Then there are facts relevant to a fact in issue, which you can think of as circumstantial evidence. And finally, collateral facts, which are all about the witnesses. Let's break them down one by one. First step, facts in issue. These are the big, central questions that the entire trial is built around. So, in a theft case, the fact in issue is, did the defendant actually take the item? In a murder trial, did the defendant cause the victim's death? These are the absolute must-prove points for the prosecution. The second category is what most of us know as circumstantial evidence. This isn't someone directly seeing the crime happen. Instead, it's a collection of facts that, when you put them all together, let the jury piece together what happened. Let me give you an example. Okay, so this is direct evidence. It's simple. A witness literally sees the crime in progress. There's a straight line from the testimony to the core question of the case. It's powerful stuff. But now, let's change the story a bit. This time, nobody actually saw the break-in, but a neighbor saw someone acting suspiciously nearby, and a few minutes later, the police find that same person holding the stolen jewelry. See, the jury has to connect the dots. No single piece proves the crime, but all of them together create a really strong inference. That is circumstantial evidence. And our last category is collateral facts. The easiest way to think about this is that it's evidence about the evidence. It has nothing to do with the crime itself, but everything to do with how trustworthy the witnesses are. For instance, asking an eyewitness if they have bad eyesight,
That doesn't prove guilt or innocence, but it definitely helps the jury decide how much they should rely on that person's testimony.
Now, of course, there are rules about this too. You can't just start digging up random dirt on a witness. But the court does allow evidence about things that directly impact their credibility, like if they have past criminal convictions, a clear bias in the case, or a known reputation for not telling the truth. This all leads us to the final and maybe the most important point of all. Just because a judge says a piece of evidence is admissible, that it's allowed in the courtroom, that doesn't mean the jury is required to believe it. And this is the huge difference between getting evidence in and actually winning the case. This is where we get the concept of the weight of evidence. How persuasive is it? How strong does it seem? How reliable is it? This is not a question for the judge to answer. This is a judgment call that is left entirely up to the jury. So here's the fundamental division of labor in a trial. The judge is the legal gatekeeper. Their question is one of law. Is this evidence allowed in? But once it's through that gate, it's all on the jury. Their question is one of fact. Okay, now that it's in, how much do we believe it? How important is it? So the next time you're watching a trial unfold on TV, remember this whole process. The rules of evidence are there to create a fair fight, but they can't create a perfect one. They filter out the noise, but they can never remove the human element. The judge opens the gate, but what happens after that? Well, justice ultimately depends on what 12 ordinary people decide to believe. The real question isn't just what's admissible, it's what's truly convincing. And that's something no rulebook can ever fully decide.